marriage equality cases before the Supreme Court, which will go under the caption of the Obergefell line of cases, involves 4 states, Michigan, Ohio, Kentucky, and Tennessee, and their laws and constitutional amendments that exclude from marriage and other family law institutions all lesbian and gay couples. The couples have challenged the constitutionality of these exclusions as a violation of the Equal Protection Clause. The Supreme Court 2 years ago struck down part of the Defense of Marriage Act, which was a federal statute excluding lesbian and gay married couples from more than 1,000 federal benefits and obligations. And in the companion case with the Windsor decision on DOMA, the Supreme Court rejected a challenge to the California exclusion based upon standing and justiciability, in other words, not on the merits. The marriage equality cases this term will address the Equal Protection Clause issues at the state level that the court did not have to address in Windsor, the DOMA case, and that it avoided in the California case. This will be one of the 2 landmark cases of the term, the Affordable Care Act case being the other one. It will be a very important articulation of the Equal Protection Clause from the Supreme Court's point of view. And particularly if the Supreme Court strikes down the remaining discriminations against lesbian and gay couples from civil marriage, it will be a landmark ruling along the lines of Brown versus Board of Education and Lawrence versus Texas for minority group excluded from important state benefits. If the lesbian and gay plaintiffs prevail in the marriage equality cases before the U.S. Supreme Court, there will probably be subsequent litigation and controversy over how broadly to apply the civil marriage recognition that is secured in those cases. There will probably be litigation over religious groups or even religious individuals running corporations who don't want to provide equal benefits to lesbian and gay employees. I think the biggest next step, however, for the LGBT rights movement will be legislative rather than judicial. Many states still do not have anti-discrimination laws that protect lesbian and gay employees, including married employees, from discrimination by employers, now including the provision of spousal benefits. The federal government still does not have a broad anti-discrimination statute barring sexual orientation discrimination in employment, public accommodations, education, and other important fora for LGBT people. So we've got to go back to the drawing board with legislatures and with administrators implementing statutes that are adopted at the federal, state, and local level. Well, if marriage equality is recognized, contrary to some of the predictions that were made in the past, lesbian and gay people will become married, the sky will not fall, there will be an enrichment of communities all over the country with lesbian and gay families, many of them raising children. However, the challenges to family law will remain just as significant after the marriage equality ruling as before. And it seems to me that the country really has got to get serious about other issues of family law, including domestic violence, including the abuse and neglect of children that have been overshadowed by the debate over allowing committed lesbian and gay couples, many raising children, into this important institution.